When we're talking about testamentary capacity as it relates to like a durable power of attorney, that's something that we have to assess all the time. And a durable power of attorney, as you may know, is where someone gives authority to make financial decisions to someone else. So if someone has already said, I want my son Frank to have my authority to make financial decisions. So you make Frank your attorney in fact, is what that's called. And then later we need to update that power of attorney because we didn't include certain provisions that are now required under Florida's laws, such as the new power of attorney statute that was enacted in October of 2011 has a whole bunch of new requirements for execution of powers of attorney. So if we had an old power of attorney and we wanted to make sure we updated it to include those new provisions, the testamentary capacity required for the execution of that document is going to be pretty low because they already have a history of wanting that individual to make those decisions. So typically what will happen in that case is I'll go in and I'll meet with the person and I'll say, do you still want Frank to manage your affairs? And if they say yes, and I say now there's some new things that we have to do, so these are some new provisions that are going to be in there. And if they have a general understanding that yes, they want Frank to manage their affairs and they want him to do these new things that are now called superpowers, they want to make sure that they include him for that, that testamentary capacity is going to be very low. I may go in and meet with a client in the morning and they may be having a bad day and they may not have that testamentary capacity. However, later after lunch, after they've had a nap and they're having a lucid interval, which means that they're having a time period where they can understand me and they can make those decisions to give Frank that authority, then we may go ahead and do the execution at that time. It's really an assessment as to whether or not they understand the value of their assets and what they're giving away. So a durable power of attorney has a lower testamentary capacity. Now, on the other hand, if we're talking about the execution of a will or a trust, that testamentary capacity is probably going to be a little bit higher because not only do they have to understand what their stuff is, they also have to understand what we're doing in each particular paragraph. It's a much more complicated document, and they need to really be able to understand that, yeah, okay, I'm having a lucid interval, but I also know what all my stuff is, and then I know that I want to give it away just like this. So it requires a higher level of understanding, and so testamentary capacity when we're doing a will as compared to a durable power of attorney is going to be usually a lot higher.